Hello and welcome to our video on the beginning stages of the unlawful detainer process in California, or what we in the first video called Stage 1. Here at Tashail Law, we assist tenants that are facing eviction all over California. We created this video series to provide information and guidance to as many self-represented tenants as possible. In this video, we'll explain the different types of notices a landlord can serve you and the various responses you can file. Understanding these steps can help you navigate the eviction process more effectively. Let's begin. In almost all cases, the law requires that the landlord serves you with a notice before they can file an eviction lawsuit. The legally sufficient ways a landlord can serve notices include personally handing the notice to you, leaving it with someone of suitable age at your residence, or posting it on your door and mailing it to you. Now let's look at the different types of notices. First, we have the 3-day notice to pay or quit. This notice is served when your landlord claims that you have failed to pay rent on time. The landlord must give you 3 days, excluding weekends and holidays, to either pay the overdue rent or move out before filing an official eviction lawsuit with the court. Next is the 3-day notice to quit. This notice is served when the landlord claims that you have violated the lease agreement in ways other than not paying rent, like damaging the property or engaging in illegal activities. Under this notice, the landlord must give you 3 days, excluding weekends and holidays, to vacate the premises before filing an official eviction lawsuit with the court. If your landlord is seeking to evict you without providing any reason, they must serve you with a 30-day notice if you have lived in the property for under a year, and a 60-day notice if you have lived there for more than 1 year. However, if your tenancy is protected under just cause protections, such as the Tenant Protection Act of 2019 and various local ordinances, these notices cannot support an eviction. We will discuss these protections in a separate video. There are also 90-day notices, but they are uncommon, so we will not discuss them today. If you do not comply with whatever the notice requests, then the landlord can file an eviction lawsuit after the notice period expires. This is not uncommon because landlords are often mistaken about their allegations or seek to evict tenants on improper grounds. After receiving a notice, you have several options to respond. Here are the main types of responses. Filing an answer allows you to present your defenses and objections to the eviction. For example, if you are served with a 3-day notice to quit, and the notice alleges that you have breached the lease by keeping a pet in the unit, but this is not true or the lease actually allows pets, you can file an answer and explain your side of the story. Another example is if the landlord has consistently accepted rent payments despite knowing about the pet, this could be an affirmative defense of waiver or estoppel. There are many defenses that can be asserted in an answer, and we will continue to create videos to explain the common defenses and when they apply. Filing an answer is the most common response to an eviction lawsuit. Another way to respond is to file a demurrer. A demurrer challenges the legal sufficiency of the landlord's complaint. For example, if the notice demands more rent than is actually due, then the notice is defective. Suppose your lease states that the monthly rent is $2,000. But notice demands $2,050 per month for the past 3 months, including $50 in late fees each month, then the notice overstates the past due rent because landlords can only seek the actual rent due and not include late fees. Even if everything in the notice and complaint is true, the case has to be dismissed because the notice is legally deficient. The third type of response to an eviction lawsuit is a motion to quash. A motion to quash argues that you were not properly served with the summons and complaint. The requirements for serving a tenant with a summons and complaint are different from the requirements to serve a notice and are very strict. If successful, a motion to quash can delay or even stop the eviction process. We will discuss this in a separate video. That is it for this video. Thank you for watching. Remember, you have 5 days, excluding weekends and holidays, to respond after being served with an eviction lawsuit. Regardless of whether you retain an attorney or not, it is crucial that you file a response with the court before the deadline to avoid losing by default. If you do decide to seek legal representation, do so as soon as possible. If you are going to represent yourself, be sure to visit evictiondefenseresources.com for free materials and instructions prepared by an eviction defense attorney, as well as all of the official court forms you need to file an initial response. We wish you the best.